Good evening and welcome. This is the 6th annual Hubbard Lecture Series of the First People of the Plains. I'm Susan Weller, the director of the University of Nebraska State Museum, and I am so pleased that you could all be here tonight to join us for what is going to be an absolutely fabulous presentation by Mary Kathryn Nagle. And I would like to say that we are so grateful to Dr. Ann Hubbard and to the Claire M. Hubbard Foundation for the generous endowment given to the State Museum, which supports this lecture. The purpose of this lecture is to help advance the understanding and appreciation of the cultural heritage of the first peoples of the Plains. And I'd now like to invite Bob Wilhelm, our new Vice Chancellor for Research and Economic Development, to the podium to make a few remarks. Bob, welcome.
Thanks. Well, thank you, Susan. I'm delighted to be attending my first Hubbard lecture since joining UNL in May. As Susan mentioned, the Hubbard Lecture Series advances our understanding and appreciation of the cultural heritage of Native Americans. Supporting and encouraging diversity in research and throughout the university is a priority at UNL. And in fact, we're in the process of increasing our efforts with a new Vice Chancellor for Diversity and Inclusion to provide even more intellectual, strategic, and visionary leadership for the university. As our esteemed lecturer, Mary Kathryn Nagle, will likely touch on tonight, we lose important contributions when we can't include all of the different thoughts and ideas, particularly the contributions of, I think we'll hear more tonight about Native American women and the larger community in many cases are limited by legal and other barriers. By identifying these barriers, we can begin to work together to remove them. And I'm really looking forward to the talk tonight and learning more about how we might foster a more inclusive community. I'd like to thank some other key event partners. Charlie Foster, the director of the Office of Academic Success. I know I'm going to meet Charlie before I get out of here. And Intercultural Services. And also Jen Deeds of the Women's Center for co-sponsoring associated events during this week of violence, a week where we put a lot of focus around the campus in Lincoln. They've also helped to welcome our speaker to the campus this week. I'm also really pleased that we could have participation and partnership from the Great Plains Art Museum and the Center for Great Plains Studies, and thank them for hosting this event. And I'd like to recognize the members of the Lecture Selection Committee who assisted in choosing tonight's speaker. Can the people on the selection committee stand up? I'd like to show some appreciation for our committee members. Really appreciate that. Okay. Well, again, I'm happy to be with you tonight, looking forward to learning more, and I'll wish everyone good ideas. And I'll turn it back over to you.
Thank you, Bob. Now, as is customary, I would like to invite Ann Hubbard forward to make a few remarks. It's thanks to Ann that we are able to have this lecture series, and we do have a small token of appreciation for you, but please.
All right. Well, I'm glad to be here for the 6th annual Hubbard Lecture. After I moved back to Nebraska, after being away for 28 years, I started volunteering up in Winnebago and then in a larger Native American community throughout the state. So it's really important for me to try and learn more about culture and to be able to share that with other people. Tonight's talk is very important to me. I was a physician for 35 years working in pediatric health care. One of the things that impacted me the most in pediatric medicine was working with children who had been abused and realizing not everybody knows that 1 in 4 girls is sexually abused before the age of 18. Young boys are also abused, but not at the same incidence. The issues of abuse and sexual predation go on then for the rest of women's lives. And it's even a bigger impact in the Native communities. So especially in a time now where you see people laughing about women who have been sexually abused, I know so many people who would not tell their stories of having been abused as a child. It's important for us all to be able to listen and respect those stories and realize that they are true. So I look forward to Mary's talk today.
And I'm going to move it out of the way, but I wanted you all to see that, as is customary, we have a small token of our appreciation for Anne. Is a framed poster. And again, thank you, Anne, so much. So our museum benefits from the support of friends like Anne and others, and we are guided by the wisdom of our museum board. And so I'd like to ask those members of the Friends Board who are with us tonight, I know I saw a few of you in the audience, would you please rise and accept our thanks for your guidance and support? Thank you. And I would like to invite our host tonight, Rick Edwards, the director of the Center for Great Plains Studies and Great Plains Art Museum, to the podium to say a few thank yous and a couple of words about the mission and wonderful building that we are in.
Thank you, Susan. You are in the Center for Great Plains Studies and the Great Plains Art Museum. If you're not familiar with the center, our mission is to promote understanding of and appreciation for the people, cultures, and natural environment of the Great Plains. We take promoting understanding of those things as our research mission, and promoting appreciation for as our outreach mission. Our research is reported in our two journals, Great Plains Quarterly and Great Plains Research, and in books we published and in other ways. Our outreach mission is carried out through public talks, such as this one, conferences, and to some extent, the art that you see around you. We also have a gallery in the lower level, so if you have a chance, I encourage you to stop and see the art in both galleries. And if you can't do it tonight, stop back and see us some other time. I do want to thank our partners in this, and we're delighted to partner with the State Museum and with the Hubbard Foundation and with Anne in presenting tonight's talk. One of the themes that we take as central to our mission is understanding and promoting appreciation for Native peoples' history, culture, and prospects. So tonight's talk is very much in line with what the center is about. So we are delighted to join with you and to welcome our guest. I would like to thank the staff of the center and the staff of the museum who put this event together. Thank you very much for all the hard work. We look forward to the talk. Thank you.
Thank you, Rick. And I'm now pleased to provide just a few words of introduction concerning tonight's distinguished speaker, Mary Kathryn Nagle. Mary Kathryn Nagle is an enrolled citizen of the Cherokee Nation. She is also a partner at Pipestem Law, PC, where she works to protect tribal sovereignty and the inherent right of Indian nations to protect their women and children from domestic violence and sexual assault. She has authored numerous briefs in federal appellate courts, including the United States Supreme Court. She also has a very creative other life. And I have really come to enjoy getting to know Mary Kathryn today and hear about her dreams and her work as a playwright. And for those of you who love the arts, I do invite you to check out the Rose Theater production of her work, which will which will open on January 25th, and I'm sure she'll be happy to tell you more about it. But first, we're going to ask Kathryn to lead us through tonight's lecture and guide our thinking about how we can move forward from here to play a more positive role in ensuring the safety of Native women. Mary Kathryn. Thank you.
Good evening. Well, it is just a joy and an honor to stand before you and with you all tonight. And thank you so much for such a wonderful welcome and for the opportunity to be here tonight and share this. And I have this extraordinarily fascinating PowerPoint to go through that has lots of points of legal analysis and connects sovereignty and safety for Native women in what I think is a very succinct and sound way. But I just want to start by noting that for me personally, how much it means to come back to Nebraska. And although I am a citizen of Cherokee Nation, we are in Oklahoma today. My family before the Trails of Tears, before our Trail of Tears was in northern Georgia. So if you're ever up in that area, Rome, Georgia is actually where my great-great-great-grandfather's house was. It's now a museum called the Chieftains Museum, named after Major Ridge. He was never a chief, but a lot of people called him a chief. He was actually the speaker of our tribal council, but more on that later. So that's sort of where I come from. I grew up, I was born in Oklahoma, but moved to Missouri and also went to high school in Kansas. So, you know, not far away from Nebraska, but certainly have never been able to claim necessarily that I'm from Nebraska, except that I got to go to law school, and I went to Tulane in New Orleans, and after graduating from law school, 2 judges in Omaha took a huge risk and for some reason decided to hire me. So, and I'm very blessed that one of them is here in the room tonight, Judge Lori Smithcamp from the United States District Court, District of Nebraska, and also Judge Joseph Battalion, who is not here with us tonight, and maybe has, you know, is tired of hearing me speak in this lifetime, but probably not. There's more of that to come for him. So, so I was clerking for both of them, and that was, you know, actually straight out of law school, a phenomenal experience. And somewhere along the way, discovered that, you know, and I hadn't heard this story growing up, that, you know, the federal district court in Omaha was the first federal court to declare Indians to be persons under the law. Now, I had grown up, and I will certainly go into this in this PowerPoint. I have numerous slides on this, and I will be very happy to go in depth on the intricacies of Wooster v. Georgia in the United States Supreme Court. But in 1832, the United States Supreme Court decided Wooster and decided that the Cherokee Nation was a sovereign nation that had the inherent right to exist, that Georgia, the federal government, President Andrew Jackson, no one could take that away from Cherokee Nation. So I grew up with my grandma telling me this, and that John Ridge, her great-grandfather, my great-great-great-grandfather, was the first Native attorney in the history of the United States. So I had this reverence, you could say, for the judiciary, and a personal understanding that at a time in U.S. history when the executive branch of the government and the legislative branch of the government wanted to eradicate us, it was the judicial branch that said, no, you have an inherent right to exist, you have the right to be here. Now, I think there are times when all 3 branches may be called into question, and I'm not going to say anything about what happened on Saturday, but you can probably guess what I might think about that. You know, I think I have a deep respect for the courts, and that started with the stories that my grandmother told me as a child and my family's relationship to that. But then clerking, I think, even further cemented that, especially because I got to clerk for, I think, 2 of the best federal judges in the federal judiciary, 2 of the most respectable, hardworking, brilliant, highly esteemed, you know, individuals out of any court. And while I was clerking for them, discovered that at this same courthouse in 1879, this decision had happened, and I couldn't believe that I hadn't read this in law school, that I hadn't learned it in elementary school. And perhaps I didn't grow up in Nebraska, but at the same time, isn't this an American decision, right? It shouldn't just be for Nebraskans to understand that. And so I, of course, went to Judge Smithcamp and Judge Battalion, and I said, gosh, you know, while I'm here clerking in this courthouse, the 130th anniversary of the trial is coming up, and we should do a theatrical reenactment of the trial in the courtroom. And I think it was Judge Battalion that was like, "Do you mean like is that like a play?" And I was like, "Yes, exactly." And he was like, "I've never heard of that play." And I was like, "Well, I'm gonna write it." And then he was like, "I hired you to be my law clerk. Like, did you miss the job description?" No, and they were actually both very gracious. And I think Judge Battalion was like, "I think I need to read the script ahead of time, but as long as I can at least read it and know, like, there's not any like obscene violence or something really ridiculous in it, maybe we can do this." And so I did, and I wrote the play. And so what's, again, sort of amazing about our gathering here tonight, the new friends that we've made today, which I have been so welcomed in the last 48 hours by so many folks around the campus, and been invited into classrooms, and have been extremely well fed. But was that now here in this room we have Judge Smithcamp, but also the director of that play that we did in the courthouse, Roxanne Walk, who is sitting right over here. And she will be directing the world premiere of the children's version of that play at the Rose Theater that opens on January 25th. So to me, it's a real homecoming today. And I see out here folks from the Ponca tribe and the Omaha tribe, and I'm sure there must be some that are Santee Sioux and Winnebago, and from many other tribes as well, right? And I just thank you all so much. And the last little piece of the puzzle is, after doing, and I will get to this PowerPoint, and don't worry, we will dissect the law very soon, but we got to take the play to the Smithsonian Museum of the American Indian after we did it here in the federal courthouse in downtown Omaha, and that was, talk about a thrill of your lifetime. I remember talking to Judge Smithcamp and Judge Battalion and just saying, "Well, what if we got a Supreme Court justice to come speak at the play?" And they're like, "Okay, well, we'll write letters to, senators and Senator Nelson and ask him to invite the justices." And then soon came the response, and Justice Sotomayor accepted the invitation. And she came. And she came and she spoke. And it was a very powerful experience. And after that, the gentleman who had been playing Chief Standing Bear in the play, he is a citizen of the Ponca tribe of Oklahoma, and if you know the story, you know the Ponca, like many of our tribes and our relatives, got split up. And so he's from the tribe down in Oklahoma today, although related to all the folks living up here that are Ponca. But he had done all the Ponca language translations and played Chief Standing Bear. And so while we were doing the play in the Smithsonian, he said, I've been doing all this work on the language for decades, and he pulled out this little notebook, and he just said, "I write down, when words come to me in Ponca, I don't have my parents to speak to anymore. We've lost so many of our speakers. But I just sort of almost speak to myself, and I write the words down. My dream would be to someday actually write and publish a dictionary of our entire language." And so I kind of talked to a few folks at the tribe and just said, well, why don't we, write and apply for an A&A grant to create a Ponca language dictionary? Now, if any of you have ever tried to draft an A&A grant, as the Administration on Native Americans, it's actually, oddly enough, housed under Health and Human Services. I think it was definitely more difficult than studying for and taking the LSAT. It was definitely more difficult than studying for and taking the bar. But we got it. And the grant came through, and it funded Lewis Hedman to create the Ponca Language Dictionary. And tonight we have in the audience Matt Bokovoy from the University of Nebraska Press, and they'll be publishing the dictionary, and it'll be coming out hopefully by January. Yeah, so. So lots of blessings, and just really wonderful to be able to come back. And I guess it was 10 years ago that I clerked here, so that's crazy. But a lot's happened in the last 10 years, and a lot's happened in the last 400 or 500 years on this land, and so we should get back to talking about that as well. So the topic for tonight's conversation is, and I'm just going to watch the time because I will talk forever about all sorts of things, is the connection between sovereignty and safety for Native women. And so I know that phrase sounds good, but what does it actually mean? And so I think for many of our tribal nations, and not to overgeneralize, I can definitely speak from the Cherokee point of view, women are life givers. Without women, our nations actually cease to exist. Because if you don't have women, you don't have the next generation of citizens. And that was something Cherokee Nation understood inherently. Many different cultures, again, I can't overgeneralize. I know Cherokee Nation's a matrilineal culture. So, in American mainstream culture, you take the name of your father. Nothing wrong with that. But for instance, in Cherokee culture, your clan, you are identified by your mother's family, right? And that is your identity. And again, it's not about a hierarchy. It's not to say that women are superior to men, or men aren't superior to women. But it's a different way of living and being and understanding, and it places women in a very special, sacred role in terms of nationhood, because you inherent in that structure, you understand that the nation wouldn't exist without women. And there are many different ways of phrasing that and saying that. I personally love the Cheyenne saying, which is, the nation shall be strong so long as the hearts of the women are not on the ground. And that's recognizing that, protecting our women isn't just like a noble thing to do, it's actually about nationhood. Women are the foundation of our nations. I think that's true in the United States too. I just think our American culture has lost that understanding, and maybe the American culture never truly had it, and we need it, right? I think we're nearing levels of crises in this country. I think we all recognize that. And so women really are the foundation of sovereignty, of nationhood. And what does sovereignty mean? Well, it can mean many different things to many different people. I've put a legal sort of textbook, Cohen's of Federal Indian Law. He says tribal sovereignty is the function by which tribes, as distinct independent political communities, qualified to exercise powers of self-government, not by virtue of any delegation of powers, but rather by reason of their original tribal sovereignty, govern their members and territories. That is a very legal definition, which I've been trained to use often in my career. I also love a quote. This is my law partner, Pipestem Law, Walter, where did that come from? Wilson Pipestem is Otoe, Missouri, and Osage, and his father, Browning Pipestem, was, I always say my great-great-grandfather was one of the first Native attorneys. He was one of the first Native professors of law, and he taught federal Indian law at OU School of Law in Oklahoma, in Norman. And also was one of the founders of the Native American Rights Fund, which has fought over decades many very critical cases in Indian country for tribal sovereignty and tribal nations. And he says, tribal sovereignty is that little voice that comes to somebody and says, it's okay, you're somebody. You come from good people. When something or someone threatens that sovereignty, we have to fight because it threatens to extinguish that voice. If that happens, none of us can hear. And so it's also a perspective of, okay, there's the legal definition. It relates to a government and land and jurisdiction and laws and who has the right to have the authority. But it's also something that we have to fight to prevent from extermination, right? I mean, I think when what Browning is saying here and what we understand as American Indians in the United States today, that our sovereignty is something we've had to fight to preserve. And anyone that's here today, right, if you are a citizen of a tribal nation and you're here today, you're still a citizen of a sovereign nation because someone that you descend from fought for that to be possible and fought against some really great odds. I think one of the most successful genocides in the history of mankind. So really that's something to think about when we think about sovereignty. And Billy Frank Jr., who's a huge advocate, you may have heard of like some of the fishing wars in the Pacific Northwest when a lot of tribes in the Northwest were fighting for their treaty fishing rights. And he was one of the big leaders in that. And he said, every time we carry an eagle feather, that's sovereignty. Every time we pick berries, that's sovereignty. Every time we dig roots, that's sovereignty. So sovereignty is also your life way, right? How has your people lived since time immemorial? And sovereignty is the inherent right to continue your way of life, whether it's hunting the buffalo or digging up a certain kind of root that your people eat, or burying your people in a certain way, or praying to Creator in your language in a certain way. That's sovereignty. I also think we have, again, I was talking about sovereignty in our families. So on the left here is my great-great-great-grandfather, John Ridge, and he was the clerk of our Cherokee Nation Tribal Council, and as I mentioned, one of the first Native attorneys in the history of the United States. And he's buried today in the northeastern corner of Cherokee Nation in Oklahoma, what is now Oklahoma. and of course was Indian territory when they got there in 1837. And next to him is Major Ridge, his father. And this is who I come from. And my grandmother is buried about 20 feet from there, and someday I will probably be buried there too. And I bring this up just to say that, sovereignty is also in our blood, right? We wouldn't be here today if it wasn't. And so my personal story of, and I have a lot to say about the legal framework, but of the connection between sovereignty and safety for Native women is that John Ridge, his father, another one of my grandfathers, Major Ridge, was the speaker of our tribal council in the 1820s. And so if you've studied that period of history at all, the state of Georgia was doing everything they could to remove us. Many different tactics. They outlawed our government and made it illegal for Cherokee Nation government to meet and perform governmental functions on Cherokee lands within the borders of Georgia. And they also made it illegal for any non-Indian American citizen to set foot on Cherokee land without the permission of the Georgia governor. And so if you were a non-native, non-Indian, and you wanted to go to visit Cherokee Nation, you had to go get the Georgia governor's blessing and sign a paper saying you stated your allegiance to the governor of Georgia and did not believe in the sovereignty of Cherokee Nation. So all these things were designed to attack the sovereignty of Cherokee Nation in the hopes that Cherokee Nation would move. And at this time, Andrew Jackson won the presidency on a national campaign platform of literally eradicating Indian nations. And if you look at his addresses to Congress at that time, he was saying they're racially inferior and we need to move them to allow for the prosperity and progress of American democracy and civilization for the betterment of all, right? It was a very, we're going to lift everyone up by getting rid of these Indian nations, and then we'll all be able to prosper. And that was the message. But gosh, these darn Cherokees would not leave. And even after, and so there were a lot of wars that were fought, and, every nation, all over the United States, faced that moment of, do we fight and stay, and knowing that our warriors will lose their lives, our families will lose their lives, we'll probably lose homes, or do we say, no, we are leaving, and we lose our ancestral homeland, whereas many of our nations have an understanding that Creator put us here on this homeland to live in harmony with the land, to protect the land for future generations. So you don't just walk away from that commitment and say, well, that's cool that our creation story says we come from Gadua Mound and that our entire understanding of who we are as a people is tied to protecting and preserving this land for future generations. We're just going to walk away from that because it's a little uncomfortable right now. That's a very tough decision to make. My grandfathers were right in the thick of it. And for the longest time, they were going to D.C. and meeting with several different presidents, even before Andrew Jackson, and saying, absolutely not. We will not move. We will never leave. And they were fighting removal. They were staunchly opposed. Well, what happened is Georgia just kept increasing the efforts and the tools they used to force Cherokee removal. Ultimately, the state of Georgia instructed its guard to rape Cherokee women. So they had created at that point a lottery system where they would come in and they would say, okay, we're going to divide up all the Cherokee land and give it away to Georgia citizens in a lottery. So if you were a white citizen of Georgia, you could win a Cherokee homestead. So actually our principal chief, John Ross, on one of his trips to visit the president, came back from Washington, D.C. and found a white Georgia family living in his home, and his wife and children were paying rent to live in the shed. That happened. When that didn't work, and so many of our people became homeless, they said, well, we'll have our men rape the Cherokee women, and that will certainly make them leave. And it really did. It created a terror, and it harmed our nation greatly. So much that in 1825, my grandfather, so you can see Major Ridge, the speaker at the bottom, signed this. This is a typed out version of the law that was passed in 1825, making it a crime for any person to come onto Cherokee lands and rape a woman. So it didn't matter if you were a citizen of France, if you were a citizen of Cherokee Nation, if you were a citizen of Georgia, if you were a citizen of Connecticut. If you came on to Cherokee lands and raped a woman, you would be arrested and prosecuted by Cherokee Nation. And of course, there was no law at that time in Congress or the Supreme Court to question Cherokee Nation's authority to do that, right? And so Cherokee Nation began doing that. Well, the state of Georgia really flipped out. And again, and so the law I mentioned earlier actually came in 1828 when the state of Georgia said, okay, well, we're going to make it illegal for any non-native to set foot on Cherokee land without the permission of the governor. Well, Reverend Samuel Wooster decided to do that. And so he was a white missionary from Vermont, and he came down to preach the gospel at Cherokee Nation, and he was an American citizen, non-native, and he refused to sign the governor's paper. He said, I'm not signing allegiance to the governor of Georgia. He respected the sovereignty of Cherokee Nation. Well, sure enough, the Georgia Guard came in and arrested him and imprisoned him and sentenced him to 4 years of hard labor for breaking Georgia law. The case goes all the way up to the Supreme Court. Cherokee Nation hires, because at that time, of course, Native attorneys couldn't argue in federal courts. So my grandfather couldn't argue this case, but they did secure the help of William Wirt, who was the former Attorney General under John Adams. And he argued the case on behalf of Cherokee Nation. And my grandfather, John Ridge, did help draft the legal papers, which actually there's a whole collection of a lot of the writings at the Gilchrist Museum in Tulsa, Oklahoma. And so when I wrote my play Sovereignty for Arena Stage in Washington, D.C., which is largely based on this story, I got to go and actually look at the original writings and use those in writing the play, which was really phenomenal. To actually get to see things from 1820s and 1830s handwritten by my great-great-great-grandfather was pretty cool. But so in this case, it goes all the way up to the Supreme Court, and Georgia's arguing, hello, Supreme Court, clearly tribal nations cannot exercise jurisdiction, criminal jurisdiction, over non-Indians, like the white, Reverend Samuel Wooster, who come onto tribal lands. Instead, that should be something the state does. Here we are, Georgia, this was within our borders. We have criminal jurisdiction only. So if we say it's a crime, because tribal nations cannot exercise criminal jurisdiction over non-Indians on tribal lands. And the Supreme Court said, you're wrong, Georgia. And Chief Justice John Marshall looked at all the treaties that Cherokee Nation had signed with the United States, and he said, quote, the only inference to be drawn from them is that the United States considered the Cherokees as a nation. And he further wrote, the treaties the United States signed with Cherokee Nation, quote, treat the Cherokees as a nation capable of maintaining the relations of peace and war and ascertain the boundaries between them and the United States. And there are many other really awesome quotes in there, but he also said Cherokee Nation alone has the exclusive right to exercise criminal jurisdiction on Cherokee lands. Now, we have a much more complicated patchwork of tribal, state, and federal criminal law today, and much has happened since 1832. But this was the Supreme Court's decision in 1832. And it's a huge victory for tribal nations and our inherent right to self-govern on our lands. And in fact, I know in my family, when this decision came down, we felt we've done it. We've secured the right to remain in our homeland. No one can move us. And it was my great-great-great-grandfather that then went to President Andrew Jackson to meet with him in the White House and just said, hey, Mr. President, good to see you. Here's the decision the Supreme Court issued. Very curious how you're going to enforce it, since that's your job as the leader of the executive branch of the government, and the Supreme Court here has declared the law, and Georgia's not abiding. They're actually disobeying it. They are still sending their militia to rape our women, and they're taking our homes and putting them up on the lottery. And so what are we doing here? And Andrew Jackson's famous quote is, John Marshall made his decision, let him enforce it. And he refused to enforce it. So that was when my grandfather said, okay, we have to sign the treaty, which became the Treaty of New Echota, whereby Cherokee Nation sold its lands east of the Mississippi and acquired land in what is now Oklahoma, but what was then Indian Territory. And the Trail of Tears and everything followed, and that's a whole other, you could lecture for hours about that. But the lessons of sovereignty, right? And here we have an instance where, as I said before, the executive branch of the government and the legislative branch of the government are really seeking to exterminate tribal nations, and the judicial branch says, no, you exist. And that, if you look at in the connections, why did the Georgia Guard why did the state of Georgia instruct its guard to rape Cherokee women? Just like the Cheyenne have that saying, right? The nation shall continue to exist so long as the hearts of the women are not on the ground. The U.S. military, the Georgia Guard, Christopher Columbus, they all understood that. That's why if you read Christopher Columbus's journals, his journey was one of conquest. When he arrived here, one of the first things he did, and this is well documented, he and his men raped indigenous women and even kidnapped and enslaved some of them and took them back to Europe. What was the true story of Pocahontas? Well, she was a young child who was kidnapped and raped and murdered across the seas. So we have repeated stories in American history that are often not told or shared, especially in their form as a Disney movie. But time and time again, right, the sexual violence against Native women has been used in a purposeful manner to achieve an end, a military ends, right, a conquest, a colonization. And I think that because we haven't had a true reckoning of that in the United States, we're still living in a culture where that is a common practice, even if it's not actually carried out by a military. So that's the true connection, right, between safety and sovereignty, safety for Native women and sovereignty. So what is the foundation of sovereignty? I gave some definitions of sovereignty earlier, but I'd just like to point out that tribal sovereignty is pre-constitutional. We existed as sovereign nations before the United States Constitution even existed. And another really interesting little tidbit, I think most Americans don't quite fully understand the impact or the import of all the treaties that were signed between tribal nations and the United States. And if you're in DC anytime soon, you should definitely, if you have not yet, go to the Smithsonian Museum of the American Indian and check out the exhibit Nation to Nation. It's a phenomenal exhibit curated by one of my esteemed mentors, Suzanne Schoen Harjo, who is Cheyenne and Muskogee Creek. And it goes through all the different treaties, hundreds of different treaties. Most of the land in the United States, if it was not completely illegally taken, was taken by treaty. And it was a document that was negotiated between two sovereigns. And the United States Constitution says that those documents, once they're ratified by the Senate and signed by the President, become the supreme law of the land. That's in our Constitution. So that's American law. That's our law as Americans. And it's how our nation came to be. So, but one of the very first things General Washington did after winning the Revolutionary War was sign a treaty with the Delaware Lenape. Now, why did he do that? Well, at that moment in history, if you think about it, the United States had just come into existence. The United States had never existed as a nation. So France, certainly Great Britain, many other Spain, other countries in the world, what is this country, right? Like, I don't recognize this country, never heard of it before. Sort of like the weird, teenage child of Great Britain. But so the United States quickly sought to show the world it was a sovereign nation by signing treaties with other sovereign nations. And one of the first treaties they signed was with the Delaware Lenape. Because at that point, our Indian nations were signing treaties with France and Great Britain, of course, and Spain, right? And so that is where the tradition of signing treaties between the United States and tribal nations comes from. It's pre-constitutional. And then it's, of course, enshrined in the Constitution. And so this is just sort of where I get into some legalese, but you can actually see, and I'm going to talk a lot about violence against Native women, but really in all aspects of our lives, you can see when you look at federal statutes, over time it is ebbed and flowed, right? Sometimes statutes have come down that enhance or restore tribal sovereignty, and sometimes statutes come down that diminish or take away from tribal sovereignty. And when they take away or diminish tribal sovereignty, we see the negative outcomes in Indian country. And then when they restore or enhance tribal sovereignty, we see the positive outcomes. So, for instance, removal and reservations, Indian Removal Act of 1830, very devastating impacts for tribal sovereignty and the health and welfare of tribal citizens. The Assimilation and Allotment Acts from the 1870s to the 1930s, the end of the treaty-making era, and when basically Congress said, we're just going to pass all the Dawes Acts. And I'm sure many of you know about the Dawes Acts, but that was basically from the 1880s until about 1906. The United States passed a series of allotment acts whereby they came in and said, okay, we're going to make an accounting of all the tribal citizens of each tribe. You each get 160 acres. Whatever land is left over that used to belong to the tribe will now be given to white settlers. And you basically broke up and tried to disassimilate the tribal governments themselves. And in fact, in Oklahoma, they outlawed, the federal government made the Cherokee Nation courts illegal. They're like, okay, your courts are illegal, they must shut down, and really tried to completely eradicate our tribal governments. Of course, we're back in full function today. That was a very, very dark era with very negative consequences and dark implications for tribal citizens at that time. Reduced Indian lands by about 90 million acres, and another 60 million acres were ceded outright or sold as surplus land. So huge, huge land loss, even after all the Trails of Tears and all of that impactful legislation from the 1830s and Andrew Jackson's era. And then there's the termination era, which I know a lot of people are familiar with here in Nebraska because the Ponca tribe of Nebraska was terminated in 1954, and along with many other tribes. And I think 109 tribal nations were terminated in the 50s and 60s. Now, many have been restored, some have not. I know the Ponca tribe of Nebraska was restored in 1991 after many, a lot of advocacy work on behalf of the tribal leaders, right? And folks who went to Congress and said, this is your federal trust, duty, and obligation to ensure our perpetual existence. We signed treaties with you, we still exist, we're still here. So you can kind of get a feel, right, for the ways in which tribal sovereignty has, we have the decision in 1832 where the Supreme Court says, yes, you have the exclusive right to exercise jurisdiction over your lands, Cherokee Nation, and thereby, as a precedent to all tribal nations. Well, in 1978, the United States Supreme Court decided Oliphant. Now, what is Oliphant? Well, it came 180 years after my grandfathers worked on Wooster. And so if you think about Wooster, Wooster was a case where, again, a white missionary came onto Cherokee lands, and Georgia said, he's breaking Georgia law, we're going to arrest him. And Cherokee Nation said, you don't have any authority to arrest him. It's on Cherokee lands. We're the only ones with criminal jurisdiction over people on our lands. Very similar yet slightly different set of facts in Oliphant. A non-native white American male comes onto the Squamish tribe's reservation for like a festival and actually gets very drunk and starts assaulting a tribal police officer, like beating up, and then gets involved in a high-speed chase and like completely wrecks a tribal police car, and like thankfully no one was horrifically injured or killed. But as you can imagine, this is sort of like very bad conduct that I think most sovereign governments would seek to curb and stop and prevent. And so the tribal police force arrested Oliphant and took him to jail, and then the prosecutor prosecuted him, and he was sentenced. I actually don't remember how long his sentence was, and he appealed it, and it went all the way up to the Supreme Court. And his argument to the Supreme Court was, "Whoa, I'm an American citizen. I don't get to vote in that tribe's election. I don't have any right to say who's on their court or who's on the jury. So how can they criminally convict me? That violates my constitutional rights as an American citizen. They can't criminally convict me of any crime." And really remarkable. He won this case. Now, I still have a hard time wrapping my head around this argument because, when I lived in Nebraska, I voted in Nebraska when I lived here, and I was, considered for that purpose a citizen of Nebraska. I didn't think that meant I could go to South Dakota and rape or kill someone and then say, well, South Dakota, I'm not a citizen in your state. I don't get to vote in your elections. You really can't exercise any criminal jurisdiction over me. Bye, but that is the argument, and people continue to make it today, and the Supreme Court bought it, and a couple other things, right, that were going on. I mean, as you know, even I think most non-lawyers understand that when the Supreme Court makes a decision, they always base it on precedent. So, what precedent was cited in this case? Well, one of the primary cases that was cited is a case called Johnson v. McIntosh. Now, Johnson v. McIntosh was decided in 1823. And the quote that Oliphant pulled from that case is, quote, "Their rights," they're referring to tribal nations, "their rights to complete sovereignty as independent nations are necessarily diminished." And Justice Rehnquist cited this and said, look, in Johnson v. McIntosh, this court decided tribal nations cannot claim legal title to their lands. So therefore, we're going to cite that and say, well, if they can't claim legal title and their rights to complete sovereignty are diminished, then obviously they can't exercise criminal jurisdiction over American citizens who come onto their lands. That was the logical conclusion. What Justice Rehnquist failed to mention is that at the heart of Johnson v. McIntosh, if you actually read the whole opinion, the court said, I quote, "Tribal nations cannot claim legal title to their land because, ... they are racially inferior savages and heathens." Now, why are they, and the court used those words. Now, why are Indians racially inferior savages and heathens? The reasons given were they don't worship Christ, and they don't know how to farm. They're savage because they hunt. Well, the irony, of course, right, is like what is one of the most protected constitutional rights today, right? Like the right to hunt. Do not take my gun away. And that, right? But apparently, that makes us as Indians like uncivilized and savage, that we want to like hunt for our food. And also that we don't know how to farm. I mean, I think anyone who's studied anything about the first non-native folks who got here is that they would have died if they hadn't been fed by the indigenous folks here, who also taught them how to farm, because they brought all their crops from over there, and when they weren't working, it was the native folks here on the eastern shoreline that said, well, why don't you try planting this? And wow, that didn't turn out so well for you. Well, here's some food we have that will feed you so you don't die. So I would say Johnson v. McIntosh is based on some untruthful and inaccurate factual assumptions. But Johnson v. McIntosh has never been overturned. It is still good law today. So, many of us will study, even if you don't go to law school, you'll study Plessy v. Ferguson. And then you'll study Brown v. Board of Education. And that's an important narrative to understand, right? I mean, we've got lots of institutions here in the United States that no matter where you are in the political spectrum, and what your morals or your values are, I think most people would agree, I hope, that as a society, well, I'm a hopeaholic. I really do think we are progressing and becoming more understanding and more compassionate for one another. It's the folks who maybe are losing in the overall power scheme that are becoming the most vocal right now about losing their status of power. And so they're very vocal and getting a lot of camera attention. But I think by and large, our society is becoming more compassionate and tolerable and just more humane. And so that I think the Plessy v. Ferguson, Brown v. Education narrative tracks that. But yet what is happening here, where we still have this case, Johnson v. McIntosh, that says this about the sovereignty of our Indian nations based on factual statements that aren't even true and are racist in their very nature, and that formed the foundation for stripping the inherent sovereignty of our tribal nations to prosecute non-natives who come onto our lands and commit crimes. Right? It's very, very problematic. That's the reality we live in today. So the loss of tribal sovereignty has many different negative outcomes. Separation from traditional food sources and medicines. So, when you've been living for thousands of years with traditional medicines, and all of a sudden you can't access those anymore, how do you provide health care to your community? When you've been feeding your people a certain way for thousands of years and you're cut off from that, how do you feed your community? Many different things. Loss of language, but disparate health outcomes, but a rise in violent crimes. And that's something I'm going to talk about more, but also high rates of unemployment and poverty. So you can see the connection between sovereignty and all the kind of the major issues that you may know about or read about in the newspaper that Indian country faces. And these are some examples of acts that have restored tribal sovereignty. So the Indian Reorganization Act of 1934, the Indian Self-Determination Act, and the Indian Child Welfare Act, which is very much under attack right now. And I could give a whole other lecture on that. Yes? Yeah, well, a brief little pause on that. So what is, I guess, ironic about that is if anyone's familiar with the Elk v. Wilkins case, which is another case that comes actually from this federal court here in Omaha. But let's back up to the 14th Amendment. What happened when the 14th Amendment? That is, if anyone understands equal protection law, so anytime someone says, well, this is unconstitutional because it is a race-based classification that violates the 14th Amendment. That comes from the 14th Amendment body of law, same body of law as Brown v. Board of Education, and a lot of our gender rights and other cases as well have come from that body of 14th Amendment law. Okay, how does the 14th Amendment prohibition against unconstitutional race-based, laws, right, apply to Indian country? And what the Supreme Court decided in Morton v. Mancari, which is a decision, I think, from, anyone know, like 1960s, I think, basically said, look, Indian, when Congress or the federal government classifies based on Indian, that's a political classification, not a racial classification. Why? I mean, it's, and I understand when at first glance it sounds kind of crazy, but because being Indian is about being a citizen of a sovereign nation that predates the United States Constitution. It's not about race. Now, there are certain racial factors that a lot of Indians share, but we've got people who racially appear black, appear Asian, appear Hispanic, appear white, right, who are Indian today because they're citizens of tribal nations. It is about a political relationship with a nation that predates the United States Constitution. It's not racial. Therefore, the 14th Amendment does not apply to congressional acts, and there are like a bazillion of them. So let me tell you, if the United States Supreme Court does say that Indian is a race-based classification, I don't know what we're going to do, because actually all of the acts that gave most states their land use the word Indian. So I guess, does all that land have to go back to the tribes because that was unconstitutional? I don't know. But they may not actually reach that outcome. But the other, so it is a political classification. Now, I think a lot of people still fight that. But the real test, I think, is go back to when the 14th Amendment was being debated, and the Senate actually proposed an amendment and said, wait a second, we're leaving Indians out. Okay, we're talking about African Americans and the freed slaves, but what about Indians? Shouldn't we include them in the 14th Amendment? Because the 14th Amendment is also about citizenship, right? And it said anyone born on this soil becomes a citizen, and you have equal protection under the law and all that. Well, the Senate debated it and rejected it and said, no, Indians are not going to get citizenship under the 14th Amendment. The 14th Amendment has no application to Indians because they're citizens of separate nations. And then in the late 1800s, right before 1900, a citizen of the Omaha tribe said, okay, I'm going to leave my tribe. I'm going to move to the city of Omaha, and I'm going to take up residency in Nebraska, and I should get to vote because the 14th Amendment happened, and if I divorce myself from my tribe, everyone has the right to vote. And Elk v. Wilkins, it went all the way to the United States Supreme Court, and the United States Supreme Court looked at that and said, no, the 14th Amendment doesn't make Indians citizens of the United States. The 14th Amendment in its entirety has no application to American Indians because they're citizens of separate nations. And in fact, when my grandmother was born, she wasn't a citizen of the United States. She didn't become a citizen until 1924, when Congress used the word Indian, which might be unconstitutional soon, I hope not, to give citizenship to tribal citizens. So we now have U.S. citizenship. But when my grandmother's father, my great-grandfather, tried to vote in state and federal elections before 1924, he was not allowed to, because he was a citizen of Cherokee Nation, but not the United States. And so this is the irony, right, is that we Indians, American Indians, are the only population that do not have a constitutional right to U.S. citizenship. Our right to U.S. citizenship comes from a statute that uses Indian as a political classification, and we now have a federal court saying that that's unconstitutional, legislating based on Indian, which is based on citizenship in a tribe. So it's a very interesting time to be in, and I think there's a desperate need for a deeper understanding of how we got to 2018 over the last several hundred years. And there's been an oversimplification of, I think, the 14th Amendment and other areas of constitutional law. And I will say, honestly, it terrifies me that this decision happened, but I think it's also a call to action for all of us who advocate for tribal sovereignty and for our children. Because, again, I will keep going here in a second, but if you know anything about the Indian Child Welfare Act, or the history of the United States, right, okay, we got Trails of Tears, okay, we all end up on reservations, and then all of a sudden it's like, wait, but they're still here. We haven't gotten rid of the Indians. Why are they still here? Well, let's pass the Dawes Act, and let's dismantle their governments and give all their land away to settlers, and then you go forward a little bit, and it's like, okay, but they're still here, and they're still practicing their culture, and they're still speaking their language, and they haven't fully assimilated into white American culture. What else can we do to eradicate their culture and their sovereignty? We can take their children from them and put them in boarding schools. So that was the next wave, right? So Trails of Tears, allotment, boarding schools. Thankfully, allotment and the Trail of Tears, that came to an end eventually, and we realized, okay, boarding schools are horrific, and in fact, most of our Native children who ended up in boarding schools, when we talk about sexual assault and domestic violence, were sexually assaulted and abused in their boarding schools. And so if you've spent any time talking to elders or anyone who's a descendant of a boarding school survivor, that is now a part of their legacy they're left to handle. After the boarding schools ended, then there were a lot of state adoption agencies and Department of Child Welfare Services who just came in and took Indian children out of Indian families. Sometimes perhaps because the child was in danger, but more often than not, just because the culture was different, or they didn't think that they should be speaking their language, or they weren't going to church, or whatever that cultural difference might be. It was just determined it was in the best interest of that child to be raised in a non-Indian family. They would have better opportunities in life if they were raised in white mainstream culture, right? So in 1978, when this act was passed, 40% of Indian children were being taken out of Indian homes, out of their biological homes, and being placed in non-Indian homes. And if you think about, again, the connection of women and sovereignty of tribal nations, what about children and sovereignty of tribal nations? Because if you're losing 40% of your children, you may not last much longer, right? Like that is just another genocidal tool to eradicate an entire nation. And so this was a real movement to preserve tribal sovereignty and to protect Indian children. And I actually do a lot of my practice as an attorney is on ICWA cases. And it's hard because sometimes the tribes that I represent say, you know what, this person really can't be a parent, and we really do need to terminate their rights as a parent. But what ICWA does is creates a framework, where in that framework, the first question under federal law is, okay, who's their immediate family? How do we keep them within the family? Which is not something that the state before ICWA was doing, and that was destroying our families and therefore destroying our nations. And so there's been a lot of, I think, interpretations and miscommunications about what ICWA actually is. And as someone who has lived and stayed up all night writing briefs about this law, I can tell you what the law does and does not do. And it provides a lot of really common sense pieces of framework and rules and sort of protocols that still give non-Indian parents a really great opportunity at being a very positive role in Indian children's lives and being foster parents, and in some cases being adoptive parents. It's just state agencies don't have the right willy-nilly and without due process to just go in and take Indian children out of homes anymore. So I mean, I could talk about ICWA for hours, but it is all related, right? It is all connected. But one of the big focus points of tonight is a victory that we had in Indian country, and that was in 2013, the Violence Against Women Act. Because in 2013, when Congress reauthorized the Violence Against Women Act, I told you about Oliphant and how in 1978 the Supreme Court stripped our tribal nations of their inherent criminal jurisdiction over non-Indians. Well, a bunch of tribal leaders and Native women survivors of domestic violence, sexual assault, attempted murders came to Congress and said, my ex-husband, after I got a protective order from my tribal court, he's non-Indian, he tried to murder me on my tribe's reservation. My tribe couldn't arrest and prosecute him because Oliphant says they have no criminal jurisdiction over him. Help. My tribe needs its criminal jurisdiction back to protect me in my own home. They came before Congress, they testified, they shared their stories with the New York Times, they were in the newspaper, and through many different forms of advocacy, a lot of it grassroots and a lot of it in communities on the ground, Congress reauthorized VAWA and restored tribal criminal jurisdiction over dating violence, domestic violence, and violation of protection orders. So Oliphant is still good law, but Congress has restored tribal criminal jurisdiction over those three crimes, which is a huge victory. Now, it's not the entirety of what we need to fully restore tribal criminal jurisdiction for any crimes committed on tribal lands. And the unfortunate reality, right, I'm sure you've heard, there's been a lot in the media lately, and as we should be talking about, murdered and missing Indigenous women, right? Our Native women are murdered and go missing at rates higher than any other population in the United States. And on some reservations, the rate at which Native women are murdered is 10 times the national average. Well, same thing. The United States Department of Justice has put out statistics in the last 10 years showing that our Native women face the highest rates of domestic violence and sexual assault as well. And this is actually one of my favorite pictures from the Dollar Journal rally. Why do Native women face the highest rates of domestic violence in the country? I think it goes hand in hand with what I said earlier about the beginnings of the conquest on this land, what Christopher Columbus's folks first did, what the U.S. military did, what the Georgia Guard did. It became a cultural practice of conquest that was never culturally called into question, right? There was never this reconciliation moment in America where our society said, no more. We know this happened, but no more. It's done. So there's the cultural component, right? And so because that didn't happen, you still have, a Disney movie that celebrates Pocahontas's marriage with people who raped and killed and murdered her. Okay, that is a very problematic reality that I think just perpetuates the violence. And then you have, Native American women are often portrayed just as like a sexy Halloween costume, right? Like the Pocahontas. How many young girls will you see pretty soon here on this college campus, non-Native, probably going out on October 31st and all the parties around then, dressed as an Indian princess, right? That dehumanization of Native women is what culturally allows the violence against us to continue. But it's also the legal framework, because the perpetrators have learned over time that they can come onto tribal lands and commit these crimes, and no one's going to arrest them because the tribal government cannot. And so these are some of the statistics. The National Institute of Justice is within the Department of Justice. More than 4 in 5 American Indian and Alaska Native women have experienced violence in their lifetime. 56% have experienced sexual violence. 55.5% have experienced physical violence by an intimate partner. 48.4% have experienced stalking, and 66% have experienced psychological aggression by an intimate partner. 56.1% of Native women who have reported experiencing sexual violence out of that. So if you think about basically over 1 in 2 Native women will experience sexual violence in her lifetime. Of those women, 96% of them have survived violence committed by at least one non-Native partner. What does that tell you? That a large percentage of the violence that Native women suffer today is committed by non-Natives. Now, that's not to say that our brothers and our family members and our own community members aren't harming our own women, right? That is happening, and I think we can all connect that back to removal, trails of tears, violence, boarding schools, the ways in which our cultural frameworks and understandings of how we treat one another since time immemorial were broken down, eradicated, and beaten out of us. But so at the same time, we have to hold our own citizens of our tribal nations and members of our families accountable for their actions. We also have to recognize that in many cases, the people committing the crimes against our women, we can't prosecute them. We can't stop it. So that actually allows the high rates of violence to continue. And it is a crisis. VAWA is a wonderful step in the right direction. As I mentioned, it restores tribal criminal jurisdiction over dating violence, domestic violence, and violation of protection orders. And this is one of my favorite photos of the signing ceremony from March 7th, 2013. I actually got to be, they signed it at the Department of Interior in Washington, D.C. It's President Obama signing it into law. And on the left, if you can see the photo, on the far left is Diane Millich. She's Southern Ute. If you Google her story, it is a miracle that she is still alive today. She shared her story in the New York Times, and I think many people credit her coming out with her story because, and I hate to make it a partisan issue, but it was. Some of the biggest champions of VAWA were Republicans, and some of the biggest opponents were Republicans. And so they didn't have enough Republican votes in the House to get it through. It had passed in the Senate with bipartisan support, with also some opposition from some Republicans, but bipartisan support in the Senate. Got to the House, not enough Republican votes. Tom Cole, who is a citizen of the Chickasaw Nation, a congressman from Oklahoma, was very supportive and spent a lot of time speaking to his fellow members of his party about the connections, local government, sovereignty, safety for your citizens, why Republicans should vote for this issue. And then everyone was saying, well, we don't have enough votes, we're not gonna get it. And Diane Millich shared her story in the New York Times, and then within like a week, or maybe it was 2 weeks, it had passed the House, and no one had seen that coming. So it was a huge miracle. Her story, she had gotten a protective order from the Southern Ute Tribal Court, and so her husband, her non-Indian husband, who had been living with her in her home on her reservation, was enjoined from having any contact with her. And of course, that I guess enraged him, and he showed up at her place of work and tried to shoot her. And so he walked in the door and fired off his gun, and the only reason she's still alive today is because her coworker saw it and shoved her out of the way and took the bullet in his shoulder. And her tribal police wanted to arrest and prosecute him, but they could not. And so the state had jurisdiction. They arrested him, and he ran away from the crime scene, and there was like a 6-hour high-speed chase with the police. When they finally arrested him, he was driving without a license, and his license had been revoked, I think, for like a drug crime. And so they charged him with reckless driving under revocation for reckless driving without a driver's license, and he went to jail for 2 years. And he tried to kill her after having several DV charges, and he's actually just been released. So she now has to worry about, will he try to kill her again? And of course, now the law has been changed, and tribes do have criminal jurisdiction over significant others, right? Domestic violence, if it's your partner committing this crime. And that applies to same-sex couples, right? That applies to any kind of domestic relationship, but it doesn't apply to strangers. So we have not solved the stranger crime. And so Lisa Bruner, who's not in this photo, but in a play that I wrote called Sliver of Full Moon, shares the story of when her daughter was raped. She was just walking down the street on their reservation one night in the summer, or maybe it was fall actually. Well, I think it was the summer. And an SUV slows down, and these 4 young white guys jump out and grab her, pull her into the SUV, rape her, and throw her out by the side of the road and drive off. Tribal government can do nothing, even post-VAWA, right? Because they weren't dating, there's no domestic violence, there's no domestic relationship, and there's no violation of protective order because she'd never seen them before, and there was no protective order. So VAWA is up for reauthorization now in 2018, and a lot of tribal advocates and tribal leaders are pushing for a further restoration of tribal jurisdiction, because there are still the holes that Oliphant created are still really there. So this is just some of the text from the Violence Against Women Act. You can read it. I won't go through it in great detail here. It's online, and you can Google Violence Against Women Act. But the title, it's called Section 904. The jurisdictional provision for tribal jurisdiction, and the formal citation, if you were to cite it in a brief, is 25 USC 1304. But this is, so connecting it a little, so, it has been mentioned that I'm a playwright, and I've written some plays, and including the one that'll be produced here in Omaha at the Rose Theater, which I hope you all can come and see in January. But one of my plays that was just produced in Washington, D.C. at Arena Stage is called Sovereignty. And in this play, I set it in 2 time periods, and was in the 1820s and 30s, and actually my grandfathers were characters. And so it told the story, and Andrew Jackson was a character, and it told the story of the fight of our tribal council and our nation and our principal chief to avoid forced removal and to survive as a nation in our homelands, and the Wooster v. Georgia case that went up to the Supreme Court. And then those actors who played someone in the past also played someone in the present. And the present day story is Cherokee Nation today in Oklahoma, and the descendant of John Ridge is an attorney. It was not autobiographical, but there were some connections. But so the main character ends up working in the Attorney General's office for Cherokee Nation. They've implemented VAWA 904's restored tribal criminal jurisdiction over non-Indians. And her partner is non-Indian, her fiance, and he actually commits domestic violence and rape, actually. And so Cherokee Nation arrests and prosecutes him. And he decides to take it all the way up to the Supreme Court and argue that any exercise of tribal criminal jurisdiction over a non-Indian American citizen violates the U.S. Constitution, regardless of what VAWA might say. Just violates the U.S. Constitution. And so at the end of the play, the young Cherokee attorney gives this argument. And I think it really sums up in a lot of ways what I see as the connection between sovereignty and safety for Native women. And so I'll read it for those of you who are sitting far away and can't quite hear it. But if I ever get to speak to the Supreme Court, these are maybe some of the words I would like for them to hear. Today, Native women face rates of domestic violence and sexual assault higher than any other population in the United States. It took 140 years to fully come into effect, but Andrew Jackson's campaign to eliminate tribal jurisdiction has reaped devastating life and death consequences for Native women. Like the arguments Georgia and President Jackson used to support the forced removal of Cherokee Nation, petitioners' arguments, and that's the non-Indian, petitioner is referring to the non-Indian who was prosecuted and arrested for domestic violence. Petitioners' arguments are based on a prejudicial view that tribal governments, tribal courts, tribal constitutions, and the entirety of tribal law must be inferior to the law created and enforced by the states and the federal government. But we're not. Nothing about us or our governments is inferior. Petitioners' arguments that Indian nations cannot exercise jurisdiction over non-Indians finds no support in the Constitution. Tribal jurisdiction over non-Indians predates the United States Constitution. So tribal jurisdiction isn't unconstitutional, it's pre-constitutional. And no sovereign, not even the United States, can strip my nation of its inherent right to protect me and my fellow Cherokee women. Wadon. That would be the speech I would give to the Supreme Court, and that was certainly the speech in the play. I will say, and this is connected to the talk I'm giving tonight, but I didn't go super in depth. I mean, I do have dueling careers, playwright and lawyer. I think that there are times when the work as a lawyer is to be highly esteemed and very valuable, but also the work as a storyteller and the stories that we tell, because sometimes I think the only way is to change a view or a set of facts or a set of laws that are based on ignorance or misinformation is to give the correct information or the fuller understanding or the story from your perspective or your family's history or your nation's history, right? And so we can file briefs in the Supreme Court and say, all the font is bad, all the font is bad, all the font is wrong. But what happens when a justice comes to your play and sits through 2 hours of this? And Justice Ginsburg did just that, and that was really exciting. She wrote me the nicest note afterwards. Just was thanking me and said how impactful the play was and how important the play was and the issues that were discussed in the play. So, again, that's a shout out to anyone who's thinking about spending their life as an artist or a storyteller. It's a very, very important role. So I know I want to get to questions very soon, but yeah, so the inherent sovereignty of our nations is under attack. One of the cases that I didn't get to talk about a lot here is Dollar General, and this is the VAWA Sovereignty Initiative. So my law firm, Pipestem Law, one of our main clients is the National Indigenous Women's Resource Center. So we file a lot of briefs on behalf of the NIWRC. And we just filed a brief in a case called Murphy. You can watch that closely. The state of Oklahoma is trying to get the Supreme Court to declare that Creek Nation no longer has a reservation. You can imagine how I might feel about that, how Creek Nation citizens might feel about that. But it actually has huge impacts because if you think about this, VAWA 904, which we've talked about, restored tribal criminal jurisdiction over crimes committed, domestic violence crimes, dating violence, violation of protection orders. But that restoration only applies to crimes committed in Indian country. Now, Indian country is a legal term under federal law, actually under a statute passed in 1948, that refers to a reservation or basically federal trust land. Okay, so if you don't have a reservation, that means if one of your citizens calls you, even if you're exercising VAWA 904 restored jurisdiction and says, okay, help me, my non-Indian husband is trying to shoot me, please come, send the police, send the tribal police. If you don't have a reservation under United States federal law, the tribal police don't have jurisdiction unless they know and can show that you're on federal trust land. So in Oklahoma, that's a huge issue because of the Dawes Act and the Allotment Acts. Most of our reservations are not federal trust land anymore. So although this may seem like a weird case about this Creek Nation reservation, actually has huge implications for safety for Native women, and we filed an amicus brief in that case. It will be argued on November 27th. And so you can read our brief is online if you Google Murphy, NIWRC, Pipestem Law. The Native American Rights Fund puts all the briefs online. They're also on the Supreme Court docket. But the one final thing I do want to talk about just a little bit, because it's on the poster, and if you have the program, are these photos from Dollar General. And this was a really impactful moment, I think, about connecting sovereignty and safety for Native women. And so just real quickly, I'll dive into this and then open it up for questions. But this was a case in 2015, and if you know anything about this case, Dollar General is a corporation that I'm sure many of you are familiar with. They opened a store on the Mississippi Choctaw Reservation in Mississippi and actually leased land from the Mississippi Band of Choctaw Indians. And so the tribe entered into a lease with them and said, okay, well, you can lease this land. It's on tribal trust land on a reservation. And said, okay, we'll lease you this land, Dollar General, so long as you sign this contract and just agree to be subject to tribal jurisdiction. Because we do actually have a whole series of laws that, and I won't go into that, in the civil side, okay, our Oliphant in 1978 took away all criminal jurisdiction over non-Indians, but the civil was preserved in a case called Montana in 1981 with a few exceptions. And so if you have a contract with a non-Indian, and they say, oh yes, we agree to tribal civil jurisdiction, then the tribe can exercise civil jurisdiction over the non-Indian. Well, so of course the tribe, knowing the law, says, well, great, we'll just sign a contract with Dollar General, and they agree to be subject to tribal civil jurisdiction. Sounds great. Here's the lease. Everything's wonderful. And a young 13-year-old Choctaw citizen goes to intern one summer in the Dollar General store and is sexually assaulted by his non-Indian store manager several times. So we know from Oliphant, right, the tribe cannot criminally prosecute the non-Indian who perpetrated those crimes, but they have civil jurisdiction. So the parents of the child brought a civil lawsuit against Dollar General for negligent supervision of their employee, which is actually a very common lawsuit when you are sexually assaulted in the workplace. If that employer was not training that, if there are just ways in which employers are held liable for the conduct of their employees all the time in many different jurisdictions, state, federal, and tribal. So in this instance, Dollar General responded, well, that's all good and everything, but this tribal court here cannot exercise jurisdiction over me, Dollar General, the corporation, because I'm a non-Indian. And, as a non-Indian, I have a constitutional right to not be subject to tribal jurisdiction in any form. And this went all the way to the Supreme Court. first, basically, this was in the tribal court, and the Mississippi Band of Choctaw Indians tribal court, the district court said, no, we have jurisdiction. They filed an interlocutory appeal to the tribal Supreme Court, and the Mississippi Band of Choctaw Indians Supreme Court said, no, we have jurisdiction. They then ran into the federal district court in the southern, and I don't think it was the southern district of Mississippi, may have been northern, and said, help us, federal court. The tribal court's trying to exercise jurisdiction over us. Tell them they can't, and give us injunctive relief, and enjoin the tribe from exercising jurisdiction. And the federal district judge looked at it and said, well, no, under the law, they have jurisdiction here. So Dollar General didn't like that answer and took it up to the Fifth Circuit Court of Appeals. And the Fifth Circuit looked at it and said, no, the tribe has jurisdiction here. So they petitioned for cert to the United States Supreme Court, and the Supreme Court granted cert. And so it was argued in December of 2015. And so my law firm did an amicus brief, again, on behalf of the National Indigenous Women's Resource Center. And this was about, because Dollar General was arguing that tribes should have no jurisdiction ever over non-Indians who come onto tribal lands, that any jurisdiction is unconstitutional. And of course, this case was based on sexual assault committed against an Indian child. And that's something that we care very deeply about, right, is our right to protect our children. So this is a photo of everyone on the day of the argument. We had hundreds of folks, natives and non-natives, show up in shawls with signs, and they mostly prayed and sang. And it was a very peaceful rally. But there were a lot of prayers and a lot of words said that day about how the connection between sovereignty and safety for Native women and children. And I will say that it was a very sad argument to be in the courtroom that day, because it seemed like there were 5 justices that were ready to vote against us and only 4 that were ready to vote for us. And that was in December of 2015. Well, the decision didn't come out until June 2016. And when it did, it was a 4-4 tie, because by that point there were only 8 justices and not 9. We had lost Justice Scalia in February 2016. So I don't want to say that, well, I think the real obvious reality is that if he was still alive, we probably would have lost that case. So not that anyone's death should be celebrated, but, and I'm not celebrating his death, but I will say he was anti-tribal sovereignty through and through. And, I think having the 4-4 tie come out the way it did, it's complicated, right? Because so Justice Kennedy was also in that lineup. He's now off the bench. Justice Gorsuch took his place. Well, not actually his place, took Justice Scalia's place. And I would say Justice Gorsuch, his track record up until now, has been very pro-tribal sovereignty when you compare him to other federal judges in the history of the United States. And again, you never know how anyone's going to come out, and we all know judges can. Every time they get a case, it's a different set of facts, and you always look at the law, and so you can't actually predict how a judge is going to come out every time. But if you look at Justice Gorsuch's track record, it is very, compared to many other justices, very pro-tribal sovereignty. And so that's very heartening for these other cases that are going to be coming up to the Supreme Court that deal with tribal sovereignty. I think the big question is, of course, what is Justice Kavanaugh going to do? His track record isn't as full. He hasn't dealt with a lot of Indian law cases or cases that relate to tribal sovereignty, but some of his decisions where he has are somewhat problematic, and at least from my point of view, of course. So, it's an uncertain time in terms of the future of tribal sovereignty in the United States and the safety for our Native women and children. But this was a victory. Because it came out 4-4, basically Dollar General asked the Supreme Court to strip tribal nations of all jurisdiction, so civil and any piece of criminal, over non-Indians. And the Supreme Court's answer was no, even if that came as a 4-4 decision, because a tie upholds the lower court decision, and the Fifth Circuit Court of Appeals affirmed tribal jurisdiction. So, this photo, and it's been so nice to see, all the graphic design for this talk is just spectacular. It's just really wonderful. I'm like, wow, that's a striking image. But it's cool to see this, because this, I think, out of many things in my career, I would say this is one of the highlights of my career, because I think it really showed what can happen when we do good advocacy, both in the courts and outside, in terms of, some people might call this a protest, but I call it an act of American citizenship, right? No one was belittling anyone, no one was putting anyone down, no one was attacking anyone. We were affirming that women and children are sacred, and that our nations have the inherent right to protect us. And maybe that Dollar General was kind of awful. But besides attacking Dollar General, we really were not attacking anyone. And And so with that, I know we have 12 minutes for a Q&A, but I do want to open it up for questions and answers. So thank you so much.
And there should be a floating mic. Okay, and I'll let you choose.
Okay. Oh, great.
Wait for the mic.
Yeah, I just wanted to, my name is Charles Baxter, and you mentioned Worcester a couple times in here, and what I see with Johnson versus McIntosh and Worcester, Johnson versus McIntosh was overruled by Worcester. Because the first time, Justice Marshall says that the immigrants that came here, if they discovered this land, you know, they had a right to, they could go to claim title to that land. But on Worcester, he says that they have a right to purchase the land. So he did overrule it, but the United States sticks with Johnson versus McIntosh because that takes everything away from you.
I could not agree with you more, and I think thank you so much for saying that.
And well, there's a couple more I want
Okay.
to bring up here. Okay, in 1926, in the not the congressional grove, but the congressional record, states in there that they define Indian reservations. One is a treaty reservation, 2 is a congressional treaty reservation, and 3 is an executive order reservation. The executive order reservation does have no rights to their land whatsoever. They can be terminated at any time. But a treaty and a congressional, they both have legal say-so over their lands. They own that land. So, you know, these are things that I'm not going to say I'm Indian, because I'm not Indian. I don't have no relationship with India. I'm Umaha. So this is the thing that I'm saying right now, is that I'm Umaha, I'm not Indian. So don't call me Indian. You know, and the way I look at the United States is they're using executive order reservations on treaty reservations. But we were too ignorant to know that. And today we still don't understand that. Because I had to look it up. You know, and I've read all this stuff, and I did a PowerPoint too. But it's got 174 slides. And this is something that, you know, I think every reservation should know the stuff that I found. You know, because we never were able to fight the legal issues on equal ground, because, you know, it's like they say, if Congress makes a law, the court has to recognize it as a law. And they're going to rule in that form of the law. So, you know, we don't have a chance. So, but there is things that we need to fight. So that's all I have to say. Thank you.
No, I very much appreciate that and agree with you. And I think it's a very important point. And it's just, and it's an important reminder that the law, we have our own sovereignty over how we describe our inherent right as our nations to self-govern and to provide for our people. And if we get too caught up in, okay, well, this is what we've been told the law is, so therefore we have to say it that way. But I recently, many of you may know Sarah Deer. She's a Creek Nation citizen who's been doing a lot of work to end domestic violence and sexual assault in Indian country. And we co-authored an article in the Harvard Law Journal on gender and the law. And it actually just came out like a month or two ago. And so in there, we tried to write that Wooster had basically overturned Johnson, and that Wooster was still good law today. And the law students on the Law Journal were like, "This isn't true. This is wrong. You can't say this." And we went back and forth and really had to fight them to say, okay, well, we won't say that Wooster overruled Johnson because apparently You know, all the law students in the law school can't agree to that, and they'll never publish our article if we try to say that. But we are going to say Wooster is good law. And again, it just is, we can all debate until we're blue in the face what the law is and what the law isn't, right? And I think we have to remember, you know, so a lot of people will say, you know, well, Congress in VAWA 2013 gave our tribes criminal jurisdiction over non-Indian. No. Congress doesn't give us criminal jurisdiction. We inherently have it. Now, how does the Supreme Court actually take it away? What authority does the Supreme Court have? You know, we're sort of living in this framework and abiding by it. But really, where does that come from, right? And I think these are really important questions because there are things that we accept that we don't have to accept. Yeah.
I'm
Yeah.
sorry, but I mean, listening to you talk about this, it really, you know, was going through my mind of all the things that I know. And the thing that I wanted to mention is that, you know, Clarence Thomas said in U.S. versus Lara in 1994, in a separate opinion, that unless the United States actually did a thorough analysis of their jurisdiction, he said that they may find that they do not have jurisdiction over any Indian reservations. You know, and this is the things that the tribes are not bringing into court. You know, since 1994, I haven't seen one case go in asking the Supreme Court to analyze their jurisdiction.
Well, I hear what you're saying. Word of caution, Justice Thomas' jurisprudence is very anti-tribal sovereignty. And if you read his concurrences in a lot of the cases that deal with tribal sovereignty, I think what you're saying is, you know, he comes from an attack on Congress shouldn't have authority under the Indian Commerce Clause, which I get that because sometimes they, you know, from our perspective, do bad things with that authority, like disestablishing a reservation made by treaty. Well, where the heck does Congress get the constitutional authority to disestablish a reservation created by treaty? But also, that's the constitutional authority for ICWA and for the restoration of tribal criminal jurisdiction in VAWA. So we're in a catch-22, truly, in Indian country. And there are some advocates who say, I don't believe in congressional authority over Indian affairs. It's not a real thing. And then some people who really hold on to it, and it's complicated, and it's not as simple perhaps as an hour-and-a-half lecture might lead one to believe. So,
Hey, Mary Kathryn,
hi.
good to see you again.
Good to see you again too.
We've been following your career over the years and try to watch what you're doing. Where you're at now, you have a certain voice, you have a certain flexibility in the things that you do. Do you have any interest in moving into judgeship where you might be more restricted? And what barriers would you have doing that?
Well, okay, honest answer. I have to say I got to clerk for Judge Laurie Smith Camp, Judge Joseph Battalion, and then on the Fifth Circuit Court of Appeals, Judge Fortunato Benavides. And I have loved every single job I've had in my life, with the exception of maybe like cleaning pools when I was in college to earn a living. But I don't know how to explain it, but I loved being in the federal courts. And for me, even the most mundane days where you're like, okay, how do we get through this really ridiculous diversity contract dispute case, you know, or whatever. To me, there was a duty there, and I love the law, and I just, yeah. I mean, I think a lot of people probably get out of law school and dream about being a federal judge someday. Now, will I ever be a federal judge? You know, Judge Laurie Smith Camp could talk about this. You have to get appointed by the president and then confirmed by the Senate. And sort of the way in which it goes about is that a senator in your sort of home state has to say, hey, I really want this person to go up. And the president has to say, yeah, that person. And so, you know, the circumstances under which that might actually happen for me someday, I think are hard for me to imagine. But then again, you never know in life. And I certainly, when I was clerking, did not imagine that I would ever have plays produced at the theaters they've now been produced at. To me, that almost seemed like a more unachievable dream than the federal judge route, even though that seems very much unachievable. So you never know what might happen. And I think it's an important question too, though. You know, right now we only have one citizen of a tribal nation working as an Article III federal judge out of, I don't know, how many federal judges do we have? Probably 900 or 1,000 if you all the district court judges, appellate, Supreme Court, okay? So out of that many, one Native judge, right? And if you think about it, because of the sovereign to sovereign relationship between tribal nations in the United States and all these laws I put up here that Congress passed, like, imagine how much Indian law goes into federal courts. A lot. So we need more natives on the federal bench. Now, how is that going to come about, and how are they going to get there? And then once you're there, as you point out, I probably wouldn't be getting to do talks like this where, because you didn't really become a representative of the bench. And I think we're all human, and I think you look at the Supreme Court and you can clearly see, okay, this person believes in this cause and this person believes in that issue. We all have our own political perspectives, our moralities, our understandings of the law, our jurisprudential philosophies. But you're not an advocate. You don't get to go on, or at least you're not supposed to be. Of course, nowadays anything happens. But traditionally, you don't go on CNN or Fox News and say blah 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 this or blah 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 that, because you are a judge. So, is that something that's a question too. And I don't know. I think it's one of those things. I'm like, well, maybe we'll answer the question if it ever gets presented. It's hard to imagine it being presented, but it's also, so for right now, I'm just writing briefs and plays, and it'd be awesome someday to write federal court decisions. I got to before. Would love to again someday. So, yes, thank you.
Thank you very much. I learned a lot here today. A couple of weeks ago, I spoke to a young activist who is at the Dakota, the pipeline. And she said that a man camp was being built. And they were so worried that more violence would be committed. And they didn't really understand the extent of her worry until right now. Because they don't have any protections. And all of those men in the camps, well, they're not boyfriends or husbands, they are strangers. And she was really concerned about how are her girls going to get to the store and going to get to school, and they do a lot of hitchhiking. And is there anything that any of us can do to protect those children?
Well, that is a very good question. Yes, and again, my law firm did also file another amicus brief on behalf of the National Indigenous Women's Resource Center in the Standing Rock case. You might think, again, what's the connection? Well, the connection is when the Army Corps was giving the approval for the easement for the pipeline to cross the Missouri River at Lake Oahe, the federal, under the Clean Water Act, the regulations and the law, the statute that gives them the authority to grant such easement requires them to find that the grant of the easement will be positive for public health, safety, and welfare. And so then we looked at the definition of public safety, health, and welfare. And it's like, how will this impact the health and welfare of the surrounding community? Well, in Fort Berthold and in the Bakken region, where all this oil is going to be extracted from to put into the pipeline that's going to cross the river, right, is also one of the highest rates of domestic violence and sexual assault in the country, in large part because of these man camps. And so we filed a brief making that statement, saying the Army Corps has to consider this. They can't just grant this easement without considering the public safety, health, and welfare impacts on Native women and children. The sex trafficking rates, in particular of Native women and children in North Dakota, are off the charts. Senator Heidi Heitkamp has talked about this openly and publicly. Former U.S. Attorney Tim Purdon has talked about this from North Dakota openly and publicly, about the skyrocketing of the sex trafficking cases in North Dakota. Anytime you take a population that isn't tethered to community, from 2005 to 2009, there was such a huge influx of oil extraction in North Dakota, in western North Dakota, that 100,000 new men who weren't living in the state before showed up, and they put them in man camps. So as you note, these are sometimes on reservations or on border towns, very near reservations, and the tribal governments don't have jurisdiction over these men. So not all of them are evil, not all of them are criminals, but some of them are. And the ones that are can just totally get away with it because of the jurisdictional holes. And so sort of those climates, those factors, all those circumstances combined with the legal framework have made it for a very dangerous situation in the Bakken for Native women and children. And so thank you for raising that issue. And what can you do? I always say VAWA 2018 is coming up for reauthorization this year. Call your members of Congress. tell your senator and your members in Congress in the House of Representatives that you are for a VAWA reauthorization that restores tribal criminal jurisdiction, and you want to know what their vote is on tribal criminal jurisdiction, and why is it that tribal governments can't arrest and prosecute anyone who comes onto tribal lands and commits crimes against Native women and children, right? And make them answer that question for you. Now, that you're probably going to get some intern that's going to be like, but it gets recorded, your phone call, and that gets relayed. And so that is part of the conversation that our leaders have to have when they go to DC is, okay, I hear you're saying it's a crisis. Let me be honest with you. You're such a small percentage of the population. So when members of Congress start to hear from people outside of Indian country and they realize that maybe other people besides natives are going to vote on these issues, then it starts to matter to them. And it really starts to resonate. And the other thing, too, is never underestimate the power of social media. We've really seen that in the Standing Rock movement. Even folks who didn't show up in North Dakota were tweeting and putting the message out, and that created the groundswell to force CNN. CNN did not want to talk about this at first. I mean, I think a lot of people think, well, Fox News didn't want to talk about it. CNN would not budge. And I was actually working a little bit behind the scenes to try to get them to care. And they're like, well, we're really working on the campaign right now. It's, we got to give Hillary Clinton her FaceTime. And okay, thank you, give Hillary Clinton FaceTime, but we've got a serious crisis in North Dakota that they would not cover until it reached a peak on social media and they realized, oh, this is what most Americans are wanting to tune into. Now we're going to cover it. And that was social media. So you actually can do a lot from your own home in your own community without having to travel anywhere.
Hi, my name's Irene White Eyes. I'm Omaha, Lakota. From Pine Ridge, and I'm from Macy. So I hear you talk about the Native women. What's going to happen with the women that have been murdered, on reservations already, and the missing, and it seems like they find a body and nothing happens. There's no investigation or anything. And nobody gets in trouble. So, there's a lot of Native women, that have that concern. And all of us here are grandmothers, and we're from the Sacred Winds Methodist Church. Here in Lincoln. And there's a lot of us, watching out for our daughters, granddaughters, making sure that they're being brought up in the right way, and plus our sons too, and our grandsons. But this has been an issue, it's going down all the way down Oklahoma, all the way down Texas, it's like, well, what's going to be done? And nothing gets done about that. And you were talking about that pipeline. Obama, I don't understand this because Obama already says no. And these people keep on, and it's like, what part of no don't you understand? And you're on, the Omaha tribe, Winnebago tribe, Santee tribe, all the Sioux up there, and you have to have that respect for them, because we know what the Constitution is, and there's some, it's within the treaties that a white person cannot go against a Native. And nobody understands that, And it's like, how can we get that message out? That you have to have that respect for these people. Because these people are sacred. So, that's all.
Well, I really thank you for sharing that and for the work that you're doing. And I think, I wish I had a better answer other than that is our reality, right? I mean, in my community, it's not too different, right? It's our grandmothers and our aunties who are fighting to protect our sisters and our mothers and our daughters. because so often it's just our family network, our tribal police have been told, you don't have jurisdiction. Some of our tribes have resources, some do not. That's a much more complicated conversation, but for a lot of our tribes who don't get federal funding for their police forces, right, especially if they're covering a large jurisdictional area, what happens? And in a lot of these cases, we can give examples, and what is so overwhelming, there are so many steps to the solution. Many people in the federal government are saying, well, we need data collection because we have all these stories that come from our families and our communities, and the feds, the people that be, say, well, we don't have the data. And the reason we don't have the data is because when our women go missing, no one records it because they don't care. So it's hard to get our minds around this, but we have to start getting the data together. And I know some of the people who I know, for instance, one of my good friends up at Standing Rock went out to her community and just said, okay, how many of you have a sister or a mother or a cousin who's been murdered or missing? And within, I think, a few towns, they had a list of 20 in a matter of like a day or two, right? I mean, that's how serious this is. And yet, when they go missing, they call the tribal police. The tribal police say, okay, well, they know we don't have jurisdiction unless we know that the perpetrator was another Indian, because the federal law framework in Oliphant tells us we don't have jurisdiction over murder or kidnapping if it's committed by a non-Indian. And then you go to the feds and you say, hey, a Native woman went missing. And they're like, well, we're really busy over here dealing with this marijuana drug deal. We'll get to that later. And it's not a priority for them. And so some people say, well, the solution is to make it a priority for the feds. I think most of us would disagree with that and say the solution is to restore the inherent right of our nations to protect our women, and then also deal with a culture that promotes violence against Native women, right? Because that's what also allows it to continue. And I think that the reason that we have made it this far, despite all the violence, is because of our grandmothers and the women in our lives who have held up and kept our nations together through some of the toughest struggles. But I know, having just barely touched the tip of the crisis in the work that I've done in Indian country, that our communities are in absolute crisis. And I know when you combine that with the loss of our children and all these different things, it's a question of how much longer can we hold on. And so are we out of time?
No, you can take another. I was
Okay.
just going to say that it's a lecture and it's your attendance here that helps spread the word and the understanding of the problem, and for really, Mary Kathryn, for you bearing witness.
Thank you.
That is so important, that we all come to understand the full extent. And so please go on, but I just wanted you to have that you being here and Mary Kathryn being here helps raise more voices.
Mm-hmm. Well, and I would say for those of you who maybe feel like this is your first introduction to the issue, I get to zip in and zip out, but you have here in this room amazing advocates from the tribes here in Nebraska, and to visit with them directly and to go to the Indian Center here in Lincoln and to introduce yourself and just say, hey, what can I do to support these issues? I don't know enough about them, but I've heard about this and I really want to do something. Or the Ponca tribe is here, the Winnebago, the Santee Sioux, or the Omaha, and just, they have domestic violence programs, they have advocacy, right? And they have advocates, and all of these programs need support and help and funding. So many things, but to get involved and to help in that way. Okay, one more question apparently. Yes.
Oh, well, good evening. Ewe de Wangide, all my relations. I just want to say thank you, Wado, to you for coming here to Nebraska and sharing all of your expertise with all of us, and also giving us that encouragement to continue on in all the endeavors that so many of us are making. And I want to introduce myself. I know you and I know each other, but I want to introduce myself to all the people here. My Umaha name is Sacred Horsewoman. my English name, as we say, Wache name, we say, the white man's name, is Renee Sansusi. And I'm from the Omaha tribe. And to state, everything that, that you have said, and to also to educate everyone who's here, there's, I can say that, these women who are sitting here from Sacred Winds, my daughter, all the Native women that I know, we're working tirelessly on these issues. And it's a never-ending process. There's so much to be done. And I can tell you that I go to bed at night, I'm like exhausted, because I'm not just working on this sole issue, because this in itself is so overwhelming. But I'm working with youth, I'm working with environmental issues, I'm teaching, I'm working with language, I'm working with elders, you name it. It's almost like my plate is so full right now, so I am exhausted. But the encouragement that we receive, from your work, is what helps us to continue. That's what I want to share with everyone who's here. And if you want to help, by all means do so, because we need that help. We need your help to, spread the word of what this is about. And yes, I am hypervigilant. I'm a single mother. I have 2 daughters and 2 sons. And believe me, I work hard to make sure that they are safe. I do everything in my power to ensure their safety. And it is scary to have them walk out the door every morning to wherever they go. So please understand that, most of us who are Native, we take this very seriously, because we can say, yes, I do know. I do know youth who have disappeared. I do know women who have disappeared. I do know what's happened. And if they are rescued, if they do return, you know that they have sustained considerable damage, just as many of our ancestors have. So the stories that we have to share, that goes back, just as what she shared about her ancestry, what her grandfathers had done, what her people have endured. We've all been through that with our tribes. We all have our stories. This is what we're bringing to light now, because, as we say amongst our people, my children are Umaha, but they're also Lakota. And they do claim both. How would that work, in a court of law if they were trying to work with my children? And I've had to go through the court system with my children when they were really young. And the jurisdiction was like, okay, we have to work through the Omaha tribal court because that's where you had resided for most of your life. But we also have to recognize the Oglala Lakota court because that's where they're enrolled. It was a very strange, I'd never ever experienced that in my life, but that's what I had to deal with in dealing with ICWA, in dealing with the rights, parental rights. And also in, my fear of being, ever since I became a single parent, was that we were gonna be separated all the time. So I fought day and night to make sure that no one was gonna separate us. And if it meant that we had to go without in order to stay together, then that's what we did. So please understand that these issues that she's touched upon, they're very real to us. We live under that constant threat. And I'm tired. But yeah, my spirit is strong. I'm gonna continue on and carrying out this work. I support everything she says. And I believe in her work, but I believe in all these women who are doing this work. So please come forward and say, you know, you want to know how you can help us, come and ask us. We will share. This is what you can do. Spread the word. Let people know. This isn't allowable. Please help us that way. And with the wangile, me ta koe asim, are my relations.
Thank you. I think I actually appreciate everything Renee just said, and we've known each other for quite a while, and I can say that in knowing Renee, I've actually watched her do this work and do it even when her own family is in crisis, and I think that is unfortunately what so many of our sisters and mothers and grandmothers have to do in our communities, is there is no time to stop and wallow in self-pity or anything that you face. You just keep fighting for your people. And I don't know everyone personally in this room that does that work, but I do know Renee and have for several years, and she even acted in one of my plays, and she's an amazing actress. But I will say, you know, she's a great contact too. I mean, everything I just talked about tonight, she's working on every day, and so if you're feeling again like, who do I talk to? Well, she just stood up and introduced herself, so please, you know that there are probably people you walk by every day here in Nebraska who are doing this work and that you can connect with here. And I just want to thank again Susan for inviting me here, and Anne for hosting this and making it possible, and for everyone else who has made this trip out here possible for me. And it's just been an honor and a privilege to tell my own story here tonight and to share just a little bit about the work that I do as a lawyer and a playwright and as a Cherokee woman. So I really thank you all, and thank you for coming and witnessing this, and for all that you will do after you leave tonight. Thank you.